Hi, everyone, and welcome to episode 17th of Study With Me, European Union Law. This podcast helps you get ready for your university exams and gain a deeper understanding of the subject. Okay, but let's make this practical right away. You sent us your class notes on the general principles of EU law. And honestly, this is, for me anyway, one of the most fascinating bits. It's where you really see the EU's sort of unwritten constitution taking shape. So our mission today, to really nail down the academic role, the function of these principles. We want you walking away with clear, examinable knowledge that actually sticks. We're talking about these, well, unwritten rules that keep the whole EU legal system fair and balanced.
Exactly. And the first thing always is context. Where do they fit? The hierarchy of sources, right?
Right. Yeah.
General principles are considered primary sources of EU law. So they're up there with the big ones, the treaties, TEU and TEF-EU, and of course, the Charter of Fundamental Rights.
Okay, primary status. That's significant, top tier. But we know the treaties are the founding documents, the ones that actually create the EU and its powers. So if the treaties are the source of authority, what does that mean for these principles? How do they relate?
That's a really important distinction to grasp. You're right, the treaties are generally seen as the higher legal source. I mean, they set up the whole game, give powers to the institutions, define competences.
Okay.
But the general principles, they hold the same primary legal value. Think of them less as the source of the power itself and more as the source of legitimacy for how that power gets used. They're the benchmarks for lawful action.
Authority versus legitimacy.
Got it.
That's a really useful way to think about it. Now, you mentioned the treaties, the charter, those are written down, codified, but these principles are often called unwritten. How can a major legal system rely so heavily on rules that aren't, formally written down in the same way?
Yeah, it's a product of history, really. It goes back to the early days of the European Economic Community. These principles were developed, articulated, clarified over time by the Court of Justice, the CJEU.
So the court kind of created them.
In a sense, yes. The original legal order was, well, brand new. There were gaps, especially concerning things like fundamental rights protection or basic procedural fairness things you'd expect in a rule of law system. The CJEU stepped in to fill those gaps, drawing inspiration to ensure the system was coherent and just. They are essentially judge-made constitutional law.
Okay, so if the court is developing these principles, where does it look? What's the basis? It can't just invent them out of thin air, surely.
No, absolutely not. The court is quite systematic about it. It primarily draws from two, you could say, interconnected sources or streams.
Okay, what are they?
First, there are principles that are kind of intrinsic to EU law itself, things needed for this unique structure to actually function. Concepts like loyal cooperation, subsidiarity, and a really key one we'll unpack later, utile effectiveness.
Makes sense. Principles needed for the union to work. What's the second stream?
The second stream is about embedding the EU within broader European legal traditions. The court looks at principles that are common to the national legal systems of the member states.
Ah, so it looks at national constitutions, national administrative law.
Exactly. It does a sort of comparative analysis, looking for common ground, common values across the different national systems. And that's where we get core principles like legality, the protection of legitimate expectations, non-discrimination, proportionality. It's about ensuring the EU operates according to standards that resonate with its members' own democratic traditions.
That's quite a powerful role for the court, though, isn't it? Deriving these fundamental primary rules from potentially diverse national traditions. Doesn't that give the judges, well, maybe even more political weight than the bodies that actually write the legislation, like the Parliament and Council? I mean, who checks the court when it's defining these unwritten rules?
That's a classic debate in EU law. The tension is definitely there. The main check, I suppose, is the court's own reasoning and its need to justify its findings based on the treaties and those common traditions. It has to build a convincing case that it's articulating something inherent in the legal order, not just inventing it. Plus, its judgments are constantly scrutinized academically and politically.
Okay, let's talk scope. How powerful are these principles? Who actually has to follow them?
Well, their reach is broad, very broad. They certainly bind the member states, particularly when they're implementing or applying EU law, but crucially, they bind the EU institutions themselves.
Ah, so the Commission, the Council, the Parliament,
Yeah.
they all have to respect these principles.
Absolutely. That's the core point. Because they have primary law status, The institutions cannot adopt secondary legislation like regulations or directives that violates these principles. And sometimes, as we saw in a case called Mangold, they can even have horizontal effects, binding private parties in certain situations, like employment non-discrimination.
Right, and that brings us to the killer point for exams. We spend so much time learning about regulations and directives secondary legislation. Why are general principles the ultimate yardstick for checking if that secondary law is actually valid?
Because they form the constitutional framework, the bedrock. Since they are primary law, they set the standard. Any act of secondary legislation must comply with them. So if you think a regulation is, say, disproportionate or violates legal certainty, you can challenge it in court, often using Article 263 TFEU, the action for annulment precisely on the grounds that it breaches a general principle. They police the boundaries of what the institutions can lawfully do.
Okay, let's make this concrete. Let's look at some key principles in action, see how they ensure legality and fairness. Starting with effet utile, or effectiveness. What's that about?
Effet utile is fundamental. Basically, it means that any provision of EU law has to be interpreted and applied in a way that actually allows it to achieve its purpose. You can't interpret a rule so narrowly or apply it in such a way that it becomes meaningless or ineffective.
So it's about making the law work in practice.
Exactly. It's about giving the rule its maximum useful effect. If there are multiple ways to read a provision, the court says you have to choose the one that best ensures the objective of that law is met.
Is there a case that illustrates that?
Sure. Think about the Adidas case, C22398. It concerned trademark law. The court insisted that the rules had to be interpreted in a way that genuinely protected the trademark across the union, giving the rules their intended useful effect, rather than an interpretation that might weaken that protection.
And what about the impact on individuals? How does effet utile help, say, you or me?
Well, it links directly to having real remedies. The court famously established this in the Brasserie-Dupicheur cases. It essentially said that the whole point of EU law, its full effectiveness, would be undermined if individuals couldn't get compensation, couldn't get redress, when their EU rights were violated, for instance by a member state. Effet utile demands that rights lead to remedies.
That's powerful. A principle ensuring accountability. Okay, if effet utile ensures EU goals are met, what keeps the system running smoothly between all the different players? That sounds like loyal cooperation, which is actually written down in Article 4(3) of the TEU.
Yes, Article 4, Paragraph 3. Sometimes called sincere cooperation. It often sounds a bit, well, vague, maybe, but it's absolutely critical for the day-to-day functioning of the EU. It's a two-way street.
Two-way.
Meaning it applies both vertically between the member states and the EU institutions and horizontally between the member states themselves and even between the EU institutions. Everyone needs to cooperate loyally.
So what does it demand from member states specifically?
Two main things. First, a positive duty. They have to take all appropriate steps, whether that's passing national laws or taking administrative action, to ensure they fulfill their obligations under the treaties and secondary legislation. If there's a directive, they have to actually transpose it properly and make it work.
And the second?
A negative duty. They must refrain from doing anything that could jeopardize the achievement of the union's objectives. So no deliberate foot-dragging or actions designed to undermine EU policies.
Okay, that covers the member states. You said it applies to institutions too. How does loyal cooperation work between, say, the Commission and the Parliament?
For the institutions, it often translates into respecting each other's roles and powers, what we call the institutional balance. For instance, the Council might need to genuinely consult the Parliament before adopting legislation. It means acting in good faith towards each other, sharing information, not trying to usurp powers. It prevents gridlock, ideally.
Right. Let's shift gears slightly. Legal certainty and legitimate expectations. Now, if I'm, say, a business operating across several EU countries, these sound incredibly important.
They absolutely are, foundational for anyone interacting with EU law. Legal certainty is essentially about predictability and clarity. Laws need to be clear, precise, accessible, usually meaning published so people know where they stand. And crucially, laws generally shouldn't be applied retroactively to negatively affect people.
So certainty is about the law being clear now. How does legitimate expectations fit in? Does that protect against future changes?
Exactly. Legitimate expectations protects reliance. If an EU institution, through its consistent actions or clear guidance, has led an individual or a company to reasonably expect a certain situation to continue, it can't just suddenly pull the rug out from under them without very good reasons or without maybe providing transitional measures.
So, if I've invested heavily based on a current EU regulation,
And you had good reason to believe it was stable, The principle of legitimate expectations means the EU institutions can't just arbitrarily change it overnight in a way that harms you without justification or some form of protection for that reliance. It provides stability.
Those three effect utile, loyal cooperation, certainty expectations really show the mechanics. We should probably quickly list the other big principles you mentioned students need to know for exams.
Definitely. Key ones include non-discrimination, which is also codified in Article 18 of the TFEU, but exists as a general principle too. Then there's institutional balance, which we touched on, often linked to the Lavers case.
Right.
Proportionality is huge, making sure EU actions don't go beyond what's necessary to achieve their aim. And increasingly relevant today, the overarching principle of the rule of law itself, which underpins everything and has been central in cases involving challenges to judicial independence in some member states, like Poland or Hungary.
That lists non-discrimination, institutional balance, proportionality, rule of law together with the ones we discussed. That's really the core toolkit, isn't it?
It really is. It's the set of fundamental standards the CJEU uses to ensure the EU operates as a legal community, not just a political arena.
Okay, let's try and synthesize this. Thinking academically now, beyond just listing principles, what's their primary role in the EU legal order?
I'd say their number one function is interpretation. They are the guiding lights. Whenever there's ambiguity in a treaty article or a directive or a regulation, EU courts, both the CJEU and national courts applying EU law, must interpret that provision in a way that is consistent with these general principles.
So they help clarify unclear law.
Yes, they ensure interpretation aligns with fundamental values like fairness, proportionality, certainty. They provide a consistent interpretative framework across the whole body of EU law.
And flowing from that, they become the standard for judicial review,
Right.
the check on power we talked about.
Precisely. That's the accountability mechanism in action. Because they have primary legal status, just like the treaties, they provide the benchmark against which the legality of secondary legislation is judged. If the Commission passes a rule that's found to be disproportionate, or the Council ignores consultation requirements breaching institutional balance,
Then that act can be challenged in court.
exactly. Under Article 263 TFEU, someone with standing can ask the CJEU to annul that act precisely because it violates a general principle of EU law. It's how the court polices the institutions.
So ultimately, this is about protecting people, businesses, everyone subject to EU law from arbitrary or unfair action by these powerful institutions.
That's the bottom line. It's the active protection of rights. These principles ensure that the exercise of EU power remains within legal bounds, promoting fairness, predictability, and accountability. They embed the rule of law deep within the EU's operational structure.
This has been super helpful. I think we've really unpacked their role. So for you, the listener, preparing for exams, here's a takeaway. General principles are these unwritten, judge-made rules at the top of the EU legal hierarchy primary law. Their job: to guide interpretation of all EU law, and crucially to act as the constitutional standard to check if secondary legislation is valid. They guarantee legality, fairness, balanced power. Essentially, they're what makes the EU, as the court said way back in the Lavers case, a community based on the rule of law.
And maybe one final thought to leave you with, connecting this back. You'll know from your studies that changing the actual treaties, the TEU or TFEU, is really difficult, right? You've got the ordinary revision procedure, simplified procedures, those passerelle clauses.
Oh, yeah, super complex, very political, often needs unanimity ratification back home. It's designed to be stable, but it's slow.
Exactly. Slow and formal. So here's the question to ponder. Given that these general principles are unwritten and they develop and evolve through the case law of the CJEU, how does that process of change, of evolution for these fundamental principles compare to the rigid process for amending the treaties? What strikes you about the flexibility or maybe the potential uncertainty that comes from having these core legal standards evolve through judicial decisions rather than formal political amendment? What does that judicial dynamism mean for the EU legal system, and maybe even for the balance of power between the courts and the political institutions? Something to think about as you continue your studies.